Ladies and gentlemen, my name is A.Belin. I'm a student of the Russian State University of Justice, and today I would like to tell you some words about the difference between mediation and arbitration in the Russian Federation. So you will note these facts during my presentation. I will tell you for which reasons the topic of the research was chosen, some words about the historical aspect of the question, then the distinguishing marks of arbitration and mediation, and of course I will make a conclusion. So the alternative dispute resolution, in the future I will name it ADR, is a group of processes and techniques that act as a means for disagreeing parties to come to an agreement short of litigation. So the meaning of the ADR is significant because of its main advantage. The main plus of it is the confidentiality. So for example, the big corporation will have an ability not to disclose its trade secrets in a state court. Two main ADRs types in the Russian Federation are mediation and arbitration. Accordingly, it is necessary to show the difference between these two types and show their significant pluses according to the relevant Russian law. So now I would like to tell you some words about the historical aspect of the question. It seems that it will be most accurate to start with consideration of the history of federal statutes governing mediation and arbitration in the modern Russia because it is related to the theme of the presentation. These two popular types of ADR appeared in Russia at different times. The most traditional ADR's variation in the Russian Federation has been arbitration. The first common federal legal act in the modern Russia about arbitration was passed in 2002. This statute regulated the general issues of the arbitration court and was quite democratic. Almost any large company could afford to create a court ad hoc based on its norms. There has been an active step-by-step preparation for the reform of legislation in this area since 2013. As it was written in the explanatory note of the law about the arbitration, which is, by the way, in force today, the current legislation governing the institute of the arbitration proceedings in the Russian Federation does not allow to ensure a high level of arbitration proceedings, as well as the real demand of the institute by participants of the civil turnover. Finally, the current federal statute was passed in 2015 and the sphere of its regulation has been changed significantly. According to the historical aspect of the arbitration, the legal institute of mediation is relatively young. The federal statute which regulates this area was passed in 2010. The purpose of this law project is to offer a convenient and fast way to resolve the disputes, which should be flexible and guarantee the enforceability of decisions taken during the mediation procedure and to save court costs, is fixed in the explanatory notes of the law about the mediation. So now it's the time to move on, and I would like to tell you some words about distinguishing marks of arbitration. So it seems that the most accurate way to show the most significant marks of any legal institute is the deliberation of principles, a bearing structure of any legal institutes, by the way, which govern this area. So arbitration shall be conducted on the basis of principle of independence of arbitrators, the dispositivity, the adversarial nature of the parties, and the equal treatment of the parties. So every arbitration court in the Russian Federation must have their own regulation, which should be connected with the federal statute. So it is necessary to underline that the arbitration is a litigation procedure but which is not related with the system of state courts. So now it's the time to tell you some words about the distinguishing marks of mediation. So the mediation procedure is based on the basis of principles of voluntarism of the parties, the confidentiality, the cooperation and the equality of the parties, the independence of the mediator. The mediation is not a litigation. It is a private talk with a mediator which usually have the main aim to solve the problem of parties. To sum up, according to my presentation, arbitration and mediation are two important parts of ADR. Each of them is governed by the special federal statute, which contains the most significant normative articles about the institute. Despite their similarity in some questions, for example, confidentiality, they are also quite different. Mediation is similar to talk and conversation, while arbitration is an alternative litigation procedure. I would like to underline again that arbitration has the main aim to find a party which is right and to make an arbitration decision. The mediation is directly opposite. The main aim is to find an agreement, not a decision, without finding a party which is right. So to sum up, there is no doubt that the EDR is a significant legal institute. Accordingly, the mediation and arbitration are also quite important. So I hope my report will be useful for you in future. Thank you for your attention. See you soon.